Welcome to the Nabil Naqvi podcast. Hello and welcome everyone to episode 1 of the Nabil Naqvi podcast, presented by Affinity Law. To give you guys a little bit of insight on what to expect in future episodes, we will be having many notable guests and hot button conversations. So I've been talking to a lot of trade lawyers, and I want to share the conversations that we've been having. So let's talk about the issue that's been making waves across the world. Tariffs. How do they impact your contracts, your clients, and your bottom line? So let's jump into it. Lawyers have had their hands full lately. We're seeing rapid changes in tariff implementation and retaliatory measures, especially between the United States and Canada. It all picked up momentum back in November of 2022, following the statements from none other than President Trump. By February and March of 2023, the U.S. announced and rolled out new tariffs on Canadian goods. Some Canadian goods qualified for exemptions under CUSMA. That's the Canadian, United States-Mexico Agreement. But Canada responded with its own retaliatory tariffs on U.S. products. This tit-for-tat created uncertainty, and businesses are now being forced to adopt their contracts to proactively manage these tariff-related risks. So first, who pays the tariff? While the importer of record usually pays tariffs to custom agencies, contracts can and often do allocate that liability differently. This is a crucial point. The party responsible for paying the tariff can and should be negotiated between the buyer and the seller. Now let's talk about the origin of goods. Tariffs apply to goods of a particular origin. For example, Canadian origin goods entering the U.S. may face tariffs depending on the classification and current trade measures. An apple grown in Canada is straightforward. But what about a manufactured product with parts sourced from 5 different countries? That's where rules of origin come in, defined under trade agreements, and often involve looking at where substantial transformation occurred during manufacturing. Now let's talk contracts. In existing agreements, you might see clauses that touch on pricing, taxes, and international commercial terms. But many of those standard provisions don't go far enough in this current complex tariff environment. Force majeure clauses, they might apply, but most require a standard of impossibility, and higher costs alone due to tariffs don't usually qualify. Instead, stronger clauses might deal with hindered performance or significant cost increases as triggers for renegotiation or relief. Now, if you're negotiating a new agreement, here's what to keep in mind. Pricing clauses. Consider indexing to the CPI to account for tariff-related inflation. Volume commitments. Build in flexibility so clients can shift volume between vendors to minimize costs. And exclusivity clauses. Avoid locking into suppliers that might be tariff-heavy. Supplier specifications. Be cautious about specifying sourcing from particular regions or suppliers. And don't forget to factor in potential government relief programs. Build contracts that protect both parties if such relief is introduced, so one party doesn't disproportionately benefit. Now, if you've already got contracts in place, what now? Great question. Start by reviewing these clauses. Have a lawyer like myself or anyone else review these clauses and the pricing adjustments, the force majeures, and the changes in any termination rights. Pay close attention to notice provisions. Missing a deadline could mean waiving your rights. Also remember the duty of good faith. How a party uses its discretion in the contract, especially during disruptions like tariffs, can be legally significant. If things escalate, review your dispute resolution provisions. Do you require negotiation first? Mediation? Maybe arbitration? Check your choice of law, your jurisdiction, clauses, and even whether your counterparty has enough assets to justify litigating against them. When negotiating workarounds or temporary relief, document everything clearly. Document. Make sure the agreement covers the duration of the relief, what triggers termination, and when the terms will be reviewed. If you're dealing with mergers and acquisition transactions, keep an eye on material adverse effect clauses. These are now being re-examined in light of the shifting tariff situation, especially when future pricing or supply chain viability is uncertain. One of the most challenging areas in this space that I find is fluid commodities like natural gas that move across borders and mix with other sources. That can be very tricky. So determining origin in these cases is complicated. You'll need to consult specific rules of origin in the applicable trade agreement. It's just another reminder of how crazy it is to manage tariffs in this highly integrated economy that we find ourselves in. So now you're asking, what's the big takeaway? Tariffs aren't just a political issue. They're a contractual minefield. And whether you're drafting new agreements or reviewing old ones, you need to think about a couple of things. Who pays? What happens when costs go up? And how will you protect yourself no matter what happens in the global trade landscape? That's it for today's episode. If you found this helpful, please be sure to subscribe and share this with someone who needs a tariff-proof contract strategy. I'll see you guys next time.